So at this point, I am going to have Romeo address the group, and then we'll be going over a couple more things before Steve takes the stage. So Romeo, go for it.
Thanks, Rhonda. Good afternoon, everyone, and a happy Friday. I just wanted to also take a moment to thank everyone for their business over this past year. It certainly was another wild year, maybe more so than 2020. So many changes were made into the payroll world and taxes and employees. And that's really why we enjoy having to do these webinars, or in the past, conferences for you. In the past, we would do these once a year and do it in person and have an all-day format. We tried that last year, doing a virtual all-day event, and we're looking at changing it up this year and having these the short one-session topics more frequently throughout the year. So we look forward to kicking this first one off. So with that, I will turn it back over to Rhonda and take it away.
One other item before I go into just two little announcements. You know the little hamburger at the bottom where it says more options? So at the bottom of your screen, you've got the three little dots. At any time that you want to change the layout of your screen, you can do so. So if you want to see, for example, the spotlight, which will be Steve, and you just want to see him and not everybody else, you can go ahead and click it to that. Auto, Google has its own idea of what auto is, but if you would like to play with that to change the layout, feel free to go ahead and do so. So just a couple of things. As you know, we are gearing up for year end. It's hard to believe that it's already December of 2021. And by the way, today is 123. So I don't know if that's anybody's like lucky angel number, but it is 123. One area that you may not be taking advantage of, which is really a big benefit and it's a cost saving to our clients, is the electronic W-2s. Your employees all have the option to elect to do an electronic W-2 versus a paper W-2, which saves time. If they lose it, they got it right there electronically, and it also saves on money for mailing. It takes them a minute to go ahead and choose to elect to do an electronic W-2. So if you need help in terms of how to do that, feel free to reach out to your specialist, reach out to any of us, and we can help you do that. But you may find that it's very advantageous for your organization, and it's certainly more efficient. The other thing I wanted to address is the employee retention credit. It is still available to businesses. And a lot of people still have not taken advantage of the employee retention credit because they didn't realize that they were even eligible. And we have been able to find millions of dollars for businesses who did take advantage of it, who did question that they were eligible. It's a very complex set of laws in terms of the rules and eligibility, and we can help you navigate that. A business can receive a maximum of $28,000 per employee. So a business with 10 employees can get $250,000 back. And it sounds too good to be true, but honestly, it's true. It's something that the IRS started. It has been going on for a year now, and we are actually starting to see our clients are getting the money back that they are eligible for. It's good for 2020 and 2021. So if you have any questions at all, it doesn't cost you a thing for us to look into it. We do take a contingency on the back end for the time that we put in to do it for you, because a process can take a week or two for us to navigate and get the answers for you. But it's really worthwhile. We've had clients that have gotten up to $500,000 back. So it's certainly worth your time to look into it. It doesn't cost you anything on the front end. And again, let us know if you want us to look into it, because we'll be happy to do it for you. And you didn't come here to listen to myself. You came to see Romeo because the beard. But anyway, I want to really take the time. It's an honor to introduce Steve Schwarzberg, who is from the law firm of Steve Schwarzberg and Associates. He has presented to over, I think, a dozen of our conferences at this point, and he is certainly a fan favorite. And he always discusses labor law. So he is a labor attorney. And for any of you women that are in your 9th month, not that kind of labor. So no questions about that. But he is going to be presenting a few hot topics in terms of what's happened in the last year and some of the changes. And I think you're going to find that it's very informative. He's certainly entertaining as well as educational, and he does like an interactive type of presentation. So at this point, I would like to say thank you so much for your time, Steve, and take over.
And Steve, I had to mute you before due to some background noise, so just unmute yourself.
Back there, fan from the computer, not from the people listening. Can you hear me okay now? Josh?
Yes, we can hear you.
Yes,
Okay.
we can.
Shall I begin?
Absolutely.
Go for it.
Oh, thank you for inviting me to speak again. I have worked very closely with PayMaster and with Romeo and the entire staff for over 12 years, I believe. And we've had the best working relationship, and I've enjoyed speaking with all of you and interacting in the annual presentations or otherwise. So I'm happy to be back again. It's a very short presentation because not much has happened in the area of HR or employment law. So I don't really have that much to say today. So I think it's going to be a very short presentation. Does anyone believe that? I don't think so. So the pace of change has accelerated beyond what anyone could have imagined. It's a moving landscape, that's for sure. So the first thing I think I want to talk about is a topic that has been raised by some of you, and I've been asked to address what's referred to as the Great Resignation. It means different things to different people, but it's a paradoxical situation where there are numerous jobs open and available, and the highest number of people have resigned from their positions. And there are all kinds of reasons. There seems to be a confluence of factors as to why that has occurred, and I guess different suggestions as to what could be done to try to deal with that phenomenon. Some people feel that we're not in Kansas anymore, Toto. The employment landscape has changed so dramatically because of COVID and still some other factors. Employees believe that they've gotten used to working from home. They've gotten used to a flexible work arrangement. They believe that there's more money to be made in another position. You may have a certain disproportionate number of women in the workforce who, because of COVID and other conditions, feel they have to take care of their children and families, and as a result, they've had to resign. You have situations where employees think that they can seek and obtain higher pay in other positions where that wasn't necessarily the case in the past. You have fear of getting sick or being exposed at work. Maybe the work environment's not as protective as it should be. You have a situation dealing with what I refer to as the politicization of the workplace, where politics is very present and involved in the workplace in many instances where it wasn't before. So you have red employers who don't want blue employees, or vice versa, or employees and employers differing on the issues of mandates or no mandates, vaccinations or not, etc. There was a time when the golden rule was there are three things that you're not supposed to talk about: sex, politics, and religion. And now it seems that the workplace is, filled with issues touching on those subjects, and in addition, health-related matters as well. So there are a lot of reasons and factors as to why. Hold on one second. There's a whole number of reasons why these resignations have occurred, and it presents challenges to employers as to what to do about it. So there are some things that can be done. Surveys have shown, first of all, that something along the lines of 40% of the workforce in some surveys indicate that they intend to leave their current positions in the next 3 to 6 months. That's an incredibly high percentage. It's hard to believe that it's going to apply across the board, but they're thinking about it. They're not, a very small portion of them will actually do it. But there are some things that can be done. First of all, employers could do something to deal with the issue of burnout that has affected their staffs the last couple of years. And some companies you've heard about just close down for a week. They just say, out of respect to our employees and everything they've gone through, we're going to shut down the business for a week and give everyone a breather. It sends a message to people that the company does care somewhat about what they've gone through and how they feel. And then there are numerous other things employers can do. Maybe allow more people to work from home, allow more flexible schedules, increase pay, maybe retention bonuses, etc. But some of the areas are interesting as to what they could do. One of them has to do with building skills. Surveys have shown that employees who believe that they can learn more at work and improve their skill levels, or maybe learn other positions or other jobs, are more apt to stay. So it's something employers will need to consider being more flexible as far as how to deal with employees. Maybe it's transitioning an employee to another field or department within the business, redeploying. The first area I mentioned is referred to as upskilling. It's a phrase. So another area, a phenomenon that's developed, is that with more openings and more people resigning, a lot of employers have resorted to hiring for very specific skills because the need for those skills have become more obvious, and employers have been more particular about who they want to hire, people with those skills that they need. And as a result, interestingly, there's been an uptick in older employees getting hired, and sometimes younger employees, depending on the field, maybe technology. And also, employers are more open to hiring employees who don't have as much formal education as maybe they would have expected or required in the past. So I think that employers have to be flexible and have some ingenuity in dealing with this issue of the Great Resignation. Another area that is obviously very hot right now is the issue of mandatory vaccinations. And we've been dealing with that issue for many, many months now, but it's really picking up some steam, especially with President Biden, the federal government, issuing proposed regulations for OSHA to implement, which were slated to go into effect as recently as the 6th, Sunday, where businesses with 100 employees or more were expected to have policy in place by the 5th and implemented by the 6th. And generally, the policy required businesses with more than 100 employees to either require mandatory vaccinations or, at least as an alternative, weekly testing with wearing face masks in the workplace. And that was one area. The other areas had to do with federal contractors and healthcare workers as well. And there have been a number of lawsuits that were filed, and I'm sure you've been following the news closely, and you're going to have to continue to follow the news on legal matters relating to these issues. But the Fifth Circuit Court of Appeal issued an injunction about 3 weeks ago, issuing a preliminary injunction stopping the implementation of the mandatory vaccination rules for employers with more than 100 employees. The court, after issuing the preliminary injunction, has required the lawyers to submit briefs to see whether the injunction should stay in place or be dissolved. Just because a court issues a preliminary injunction doesn't necessarily mean the injunction will be allowed to stand. So any day now there could be a ruling, as from that court. There have been other courts, I think the Sixth Circuit in the Midwest issued mandatory preliminary injunction as well with regard to vaccination requirements among government workers and healthcare workers. You know that DeSantis in Florida and the Republican-controlled legislature passed legislation. The public misunderstood it to be legislation that basically didn't require, mandatory vaccinations or wearing masks, but all it really did was add a couple of exemptions. Under the federal guidelines, when employers impose requirements for mandatory vaccinations, you probably all know that there are exceptions, and they're referred to as exemptions. If there's a health-related exemption where an employee can show through a doctor's letter or otherwise that the employee cannot get a vaccination, it wouldn't be healthy and would put the patient at risk, they may qualify for an exemption based on health condition. There's also an exemption for what's referred to as sincerely held religious beliefs, which is a little bit more difficult to deal with. And then third area was pregnancy. If an employee was pregnant, that was a basis for it being exempt. The Florida state law added a very strange additional exemption that said something like, if the employee could demonstrate that because the employee already had COVID, the employee had built up antibodies and therefore there was no need or reason for the employee to be required to get a vaccination without any real guidance as to how an employee was supposed to go about doing that. So there was a lot of publicity associated with it, but it may not have changed things that much because the employer could still impose a mandatory vaccination requirement so long as they allowed the exemption on the healthcare, exemption for sincerely held religious beliefs, pregnancy, etc. On the issue of sincerely held religious beliefs, the EEOC on October 25th issued guidelines giving some guidance to employers and employees on how to deal with that issue. The employer is allowed to make some reasonable inquiry as to what the objective basis is for the employee claiming a sincerely held religious belief. And it's not supposed to be so intrusive, but the employee has some obligation to come forward with some objective presentation as to what the source is of this sincerely held religious belief. Just being against vaccines is not enough. Just being against a particular kind of vaccines is not enough. There's got to be some rational basis that seems reasonable as to there being a sincerely held religious belief. I will, if I haven't told you already in a prior presentation, there's one lawyer who contacted me whose firm required the lawyers to be vaccinated and come back to work physically unless they had a religious exemption. This lawyer responded and said she had a religious basis for refusing to get the vaccine, and the law firm responded with a form that asked her to provide the book, page, and verse of whatever scripture or religious text the employee was relying upon. And it's a little bit of a slippery slope because there are no real hard and fast definitions as to what's an organized religion or a formal religion. So it's potentially precarious for an employer to fire an employee for not coming back after the employee claims a basis for a religious discrimination, a religious basis for the exemption. So you have a situation where things are in a state of flux, and you're going to have to continue to monitor it with regard to the issue of mandatory vaccinations, at least with regard to businesses over 100 or federal contractors or healthcare, state and federal. And to the extent that federal rules are allowed to be applied, they may preempt attempts by states or cities to have separate rules. So the prudent course of action currently that a lot of advisors are giving is be prepared to comply with the federal requirements. So have a plan in place. You can either go, mandatory vaccination approach, or you can go, weekly testing and wearing a mask, et cetera. But you do need a plan in place. And generally, you want a plan in place for these kinds of things, because if you don't, you're going to be open to an accusation that there was inconsistent policy, inconsistent application, and the real reason someone was fired or disciplined was not because they didn't comply with the policy that was never written down, but because of discrimination or otherwise. With regard to the hardship on the health related matters, there is the employer is allowed to not provide a reasonable accommodation requested by an employee if there's a hardship, undue hardship. And generally speaking, when an employee has a disability or qualifies for protection under the Americans with Disabilities Act, the employer and asks for an accommodation, an employer is allowed to refuse the request for an accommodation if providing it causes an undue hardship. And the case law is not so specific as to what is the standard or what is the level of whether an undue hardship exists or not. Just because an employer has to spend a little more money or allow someone to work from home or have flexible schedule or intermittent leave or whatever the reasonable accommodation is, those things by themselves may not be enough. It's got to be something that has a real substantial impact on the business. And that's a case-by-case analysis because every business is different. Every employee's position is different. How many people are in that department? Does the person really have to be there in person to do it or not? The fact that so many of us have been doing our jobs from home since March 13th of 2020 or thereabouts, relatively well. I guess that's open to speculation. Maybe not as well, but well enough. And then all of a sudden, an employer says, "I've decided it's time, and you must be here to do your job. If you can't, then we're gonna fire you and bring in someone who will." And by the way, you have to be vaccinated when you do that as well. If the employee has a credible request for an accommodation, the issue becomes, does the employer have an undue hardship? Generally speaking, the courts have not made it easy for employers to show that they have an undue hardship. So it's got to be something substantial where it has a large impact on productivity or expense for an employer to get away with that. So I did want to address those issues. On the issue of dealing with accommodations, I wanted to emphasize some practice pointers. If you have an employee who asks for time off, or even working from home, there are still some other considerations. Does the company have a leave policy that might apply in general? Does the employee have a PTO bank that still has days or time or money available? Is there a short-term disability policy that the company might be providing that might be at play that the employee could take advantage of? Some companies make a mistake of basically outsourcing their FMLA evaluation based on what an insurance carrier will decide on the issue of short-term disability. And that's a mistake because the standards are different, and an employee should make its own independent determination as to whether someone qualifies for corporate leave. And then there's FMLA. So if you have Family Medical Leave Act leave entitlement up to 12 weeks, it could be intermittent. It doesn't have to be taken all at once. You have to figure out what that employee's 12-month period is in order to figure out how many weeks they may have left. If the employer has reason to know of a hospitalization of the employee, or if the employee asks for leave and asks for it reasonably promptly under the circumstances, unless it's emergency, the employer, let's face it, if more than 50 employees within the radius of the 75-mile radius of the employment facility, for an employee with at least 1,250 hours in the prior year, if FMLA kicks in, then the employer has an affirmative obligation to send the FMLA paperwork. Cannot sit back and wait. Must send the paperwork to see if an employee is eligible or not. If the employee qualifies and is granted FMLA leave, you all know that you can't retaliate against the employee. You have to keep the job open, or a reasonably similar job open for the employee. Can't take it away. And what some employers don't realize is that when the 12-week period of leave is up, the employee may still qualify for reasonable accommodation under the ADA. So just because the 12 weeks are up and the employee doesn't show up the next day, some employers mark the calendar for the one day after 12 weeks, and as soon as the employee doesn't show up, they fire him. You have a retaliation problem, and you have a failure to accommodate a potential problem under the Americans with Disabilities Act. Under the ADA, an employer has an affirmative obligation to engage in what we all know is the interactive process. So if the employer is informed that an employee qualifies for a disability, a major life function is substantially impaired, and the employee is still able to perform the essential job functions with or without an accommodation, the employer has an obligation to engage and communicate in an interactive process. The employee has to engage also. What are your needs? What are your issues? Is there something we can do for you to make this work? So there are many instances where someone exhausts their 12 weeks of FMLA leave, but asks for reasonable accommodation, and there's no specific period of time on the ADA reasonable accommodation. So how long might the accommodation be? The accommodation may be more than 12 weeks more, etc. One other point that a lot of people ask about is, can you stack these benefits on top of one another, or do they run one after each other? The general rule is you can stack. So if somebody is out on workers' comp, if someone's out under the corporate leave policy, short-term disability, FMLA, ADA accommodation, you can stack, or PTO, you can stack those benefits on top of one another. So, and just track them, and just keep track, so that if they exhaust the 12 weeks that way, fine. That's what's occurred. They don't have to run after one another so that it's much longer, etc. So but you do want to keep track, and you want to keep the employee informed of what that employee's status is. On that point, a lot of companies have policies in their handbook that are in the nature of no call, no show. Sometimes an employee just doesn't call, and you don't know why. You don't know what the reason is, and sometimes it's helpful to have a policy where if an employee doesn't call for 3 days or doesn't show up for 3 days, and you don't know what's happened to the employee, there's an assumption, a presumption that the employee has quit or abandoned their position. So the company can act on that, and it would be helpful if it's in the handbook and the employee has acknowledged it and signed an acknowledgement. So those are some of the points I thought I would raise. As far as some other practical suggestions, keep in mind that you have to look at things on the federal level, state level, and local. So, for example, Palm Beach County amended its human rights, civil rights ordinance, where it basically applies the Title VII kind of claims that protect employees on the federal level, where if you have 15 or more employees, then the Title VII statutes protecting the employees in the protected classes kick in. On the state level, under Chapter 760, it's the same 15 employee level, but on the county level, it's been reduced to 5 employees. So I think Miami-Dade, Broward, and Palm Beach County all are at a 5 employee level. So all those laws apply for the protection of employees. So you need to be aware of that, even if you're a relatively small business. And the other thing, keep in mind, a lot of businesses say, well, we only have 4 W-2 employees, so it doesn't apply to us, or 14, depending on the circumstance. So it could be a mistake to say that if you have 22 independent contractors and most of them are in fact and in truth employees. So just because you treat someone as a 1099 independent contractor, if after the various tests are applied and the various factors are applied to see whether that worker is a W-2 employee or a 1099 independent contractor, you may find out that you've misclassified someone and they really are an employee for the purposes of counting, and now you're over 5, and now the county ordinance will apply. Keep in mind, the under 15 applies only to claims that might be brought through the county process. It doesn't lower the number on the federal Title VII or the state Chapter 760, Florida Civil Rights Act. So the number of employees and how you classify them should be taken into account. That's one of the reasons why you want to do an audit and be satisfied that you've counted correctly when you're counting employees. With regard to the ADA and reasonable accommodations and thinking about whether that employee can perform the essential functions of their job with or without an accommodation, you want to have a good job description which identifies and highlights what the essential functions of the job are for that employee. Because if you don't have a job description, how do you really know what are the essential functions? The employee says, well, I can do these 10 functions. And the employer says, yeah, but you can't do these 2 or these 3. And then the employee says, yeah, but you never identified them as essential functions of my job. They're just some of the things you expected me to do. So I've been involved in significant litigation on just that issue. So some suggestions, you want to avoid retaliation. If someone exercises their rights to request a leave because of a condition, keep in mind, number one, that the rights to Americans with Disabilities Act, disability discrimination protection, it applies in a number of different ways. There are 3 ways. One, the person actually has a disability based on what the law says. Number 2, they may not have a disability, but the employer regards them as having a disability or perceives them as having a disability. That could implicate the application of the statute. Or third, the person has a history of having had a disability. Maybe they've had cancer in the past and the employer wants to discriminate against the employee and not hire them or not otherwise comply with requirements because they had a history. So there are 3 ways in which the disability protection can apply. So you want to be careful about what you say and what's written and discussed concerning an employee. Don't make assumptions. Just see whether, in fact, the employee qualifies for having a disability. And the other thing is, if they've applied for FMLA, or if they've made a claim in Title VII for sexual harassment, reasonable accommodation, whatever it may be, based on age, gender, race, religion, national origin, sexual orientation, whatever it may be, if they don't have a real basis for it and they're not entitled to it, they can still sue if you retaliate against them for having asked for it or having participated in an investigation of someone being denied or a complaint that someone may make. So the issue of the amount of damages that an employee can get if there's discrimination might be limited. But if you retaliate and you fire them and they can't get another job for 2 years, they may have a very large claim. So you want to avoid retaliation at all costs. The Supreme Court has defined retaliation as being just about anything that would dissuade an employee from stepping forward and making a complaint. And it could be something inside the employment or even outside of employment. So you want to be careful not to take any adverse employment action against somebody who's made a claim. As soon as someone makes a claim, you want to advise everyone up in the management chain not to take any adverse action of any kind. Don't move their desk. Don't deny them a vacation. Don't deny an accommodation. Don't make comments. Don't do anything that the person could claim was a form of retaliation. The 11th Circuit Court of Appeal that covers Florida has ruled a couple years ago that any kind of harassment or hostile work environment could provide the basis for a retaliation claim. So sometimes the harassment and the hostile environment becomes so great because everyone's pissed off at the fact the person made a claim that sometimes the employee cannot perform their job and they claim constructive termination. And now all of a sudden they basically claim they were really fired, in fact, and then they could have a much larger claim. So you have to alert management immediately, hands off, everything gets run through HR or legal counsel, and be sure that things are handled, be even more sure that things are handled appropriately. There's one rule, the other suggestion before we get to the rule, the other main suggestion is, you've heard me say it before, make sure you have employment practices liability insurance, EPLI, because it could be a lifesaver where claims are made. If you have the insurance in place, then the cost of defending the company is covered, and maybe the only exposure the company has is as to the deductible. So if it's $10,000 or $25,000, that's it. The company does not have more exposure than that. So it's important to have that kind of insurance. And generally speaking, it's not that expensive, but it could be very helpful to the company. So you may want to ensure you have that in place. The other thing is the rule. If there's one rule to abide by and to remember and to have in the front of your mind, it's what most of us would refer to as the golden rule. And basically, if you treat employees respectfully, if you treat employees the way you would want to be treated, or said differently, if you treat employees the way they want to be treated, with some consideration and respect, that could go a long way towards avoiding issues and problems. It doesn't mean you have to agree to everything the employee wants, but sometimes a good bedside manner can avoid a problem rather than being dismissive or being curt or acting in a way which allows the employee to feel that they're being disrespected. So those are some general comments. There are, a number of areas that remain hot and trending. But before I even mention them, some other suggestions you've heard me make, I'm going to remind you. It's a good idea for the employer to have a mandatory arbitration policy in place. Employees and lawyers who represent them do not like mandatory arbitration policies in general. They believe they have more leverage if they can go to court and have a jury, decide their fate. During the pandemic, it was a little different because it was hard to get to court and get through a matter. But maybe there's light at the end of the tunnel. So it's a good idea to have a mandatory arbitration policy in place. You also want to consider restrictive covenant agreements, where you have non-competes, non-solicitation of employees or clients, and you want to have non-disclosure provisions as well, where the employee understands that the employee cannot disclose anything confidential or proprietary about the business. So it's in the agreement, it's in the handbook, they've signed it, they know it, and they can get sued for it. You should have an information technology policy, if you don't have one, where the employees know what it is they're allowed to use and not use. If they can use anything for personal use, it's going to be very limited and almost on an emergency basis. There can be some use of it, but it cannot be abused or be excessive use. To show you why it's necessary to keep looking at your employee handbook and make sure you've revised it and it's up to date. I have a client who recently had an issue about a healthcare client who had an issue about imposing discipline and firing healthcare workers who were vaping in and around patients who were being treated. And the question came up, was there an anti-vaping policy? There was an anti-smoking policy. And a question came up, is smoking the same thing as vaping? Maybe you all know the answer. It wasn't so obvious to me. but you may want to review your employee handbooks to make sure that it covers the areas that you want to cover. Overtime has always been hot, always will be, especially with teleworking and the lack of an ability to keep, the employer to be standing over the employee and keeping track of who's coming and going and who's working, who's really not working. There's a lot of technology in place if you want to try to keep track of whether employees are really working or not. Basically, when those kinds of technologies are created, sooner or later, some employee figures out a way to get around it. So you're gonna have to continue to monitor that if you care to be careful about it. So I could go on about a lot of other areas. Why don't I stop? I'm sure there are questions. I'll try to respond as best I can. Can I make a suggestion that you try not to give me the real names of the people involved, or discuss it openly to the point where somebody might be able to figure it out and it might be an issue or problem. I'm not your lawyer, so I'm not, it's not attorney-client privileged, so it's not confidential. If you can, a generalized question is better than one that's specific as to your business and your situation, because if it's general, maybe everyone can benefit from the discussion. So thank you for allowing me to join you again. I'll repeat that I like to present. It's been an opportunity for me to get new clients when people have an issue or a question. So feel free to call me and we can have an initial conference or consultation and see where that develops. But thank you very much. Thank you.
You can't hear all the applause, but they're plentiful.
Thank you.
Steve, we had a couple of questions come in, so I'm going to go ahead and read those that have been put into the Q&A, and then what we will do is unmute people, and they can go ahead and ask you at will. But we had a question come in from Carol. Who's going to pay for weekly COVID testing, employer or employee? And I'm assuming since the testing is free, she's probably meaning maybe the time off. And Carol, if you want to clarify that in the chat.
So I don't know I don't have a definitive answer on that question. I do know that Biden and the administration said just recently that they want to have home testing and they want the insurance companies to be liable to cover it. Exactly how they implement that and whether they're really able to do that, I don't know. I do know that employers have voluntarily provided incentives to employees where they say, we'll pay for your testing if you have a little day or two of a problem after getting tested, we'll pay your salary or compensation after that. So you don't, it's an incentive for them to go out and get tested. As to whether an employer has an obligation to pay for it if they require it, I don't think they do. And it may be something that the employee has to pay if the employer requires it and doesn't cover the cost of it until there's a requirement that insurance is obligated to pay for it.
Okay, excellent. The next question that we have comes in from Tulin. Can we ask for documentation for religious exemption for COVID vaccine, like something from a church that they belong to? If not, how do we know they are requesting vaccine exemption sincerely due to religious belief?
Yeah, that's a very good question. So basically, you can't get too intrusive. You can ask generally, but you really can't get too specific. I can honestly tell you, I haven't heard of anyone saying, give me a letter from your pastor, imam, rabbi, minister, priest, a religious leader. I don't believe there's any authority or basis for that. But the employer is allowed to make some limited, unintrusive, reasonable inquiry as to the objective basis for that sincerely held religious belief. Exactly what that means, in what context, I don't think I can answer specifically. So it would be a case-by-case basis.
Okay, let me look in chat and see if we have. Everyone ask a question via chat or by raising your hand. So at this point, I am going to ask anyone out there if they have any questions to please raise your hand. And the little hand thingamabobber, okay, is down there at the bottom. So you just click on that. Hand thingamabobber, that's technical. Oh, and then we have another question. Are we allowed to be particular about medical proof on the medical exemption? Like if we have if we get a document from another country with a translation, it looks like it's from the employee saying the employee is allergic to the vaccines.
So as I understand the question, where an employer has some doubt as to the legitimacy of the documentation, yes, the employer can inquire further for more explanation, better explanation, et cetera, et cetera. Maybe some of you have heard there are these fly-by-night little online businesses that have propped up where if you want a phony, fake medical letter, you can ask for one, buy one, and get one. So there's a lot of fraud involved in that process. And I think you've all heard some stories about there have been some NFL players who were disciplined, I think just yesterday, and suspended for games and lost salary relative to them making misrepresentations as to their vaccinated status. So the employer has a right to make some reasonable inquiry, but it's got to be related to that request for the exemption, et cetera. It can't go on a fishing expedition.
Okay, thank you.
Sure.
We have another question that just came in. One of our employees had a major car accident, non-work related. He's not eligible for FMLA. Does ADA apply here? He will not be able to work for months and he was a laborer in the landscape industry.
So the answer is, as I understand the question, the ADA applies day one and has no preconditions. If you have enough employees, 15 or more on a federal or state claim, or 5 or more in Palm Beach County, real employees, then there is an obligation to consider and apply a reasonable accommodation. And sometimes if you have this accident, unrelated to the job, you're allowed to ask for an accommodation. I need to sit at the cash register at Publix, because of my condition, until I get better. My doctor's note says so. So, generally, yes. But when you ask for an accommodation, you still have to show that you're capable of performing the essential functions of your job with or without the accommodation. A form of accommodation is leave, where, because of this accident, I need 6 weeks off. I need 5 weeks off just to recuperate and lie in bed. That may be a reasonable accommodation under the circumstances. Under the FMLA guarantees that your job will be waiting for you. Interestingly, under the FMLA, it doesn't mean the employer can never fire you. If the employer was going to fire you anyway, and you happen to qualify for FMLA, qualifying for FMLA doesn't give you some protective cloak where you could never get fired. For example, if all the employees in the Illinois office they're going to close the Illinois office, and you're out on FMLA leave, you can get fired. So on the ADA, just because you might qualify, you still have to show that you can perform the essential functions of your job with or without the accommodation. But then some of the accommodation might be leave where you don't have to do any work at all for a while.
Okay. I have a question here from Mo. Can an employee deny service to a customer if they feel like the customer they are being sent to service is not safe in terms of COVID? If they don't like that they are not wearing masks or something like that. We are a pest control company, and some of our techs have brought that up.
So that's a really interesting question. I'll give you my reaction to it. I'm going to put, number one, every employer has an obligation to provide for safety of employees. So employees, should not be put into an environment that's unsafe. In a situation where a pest control person thought that they were being asked to enter into an unsafe environment, I think that employee has a right to complain about that to the employer. The employer may say, "Well, I don't agree with you. I'm going to fire you." At that point, it turns out that under the OSHA rules that mandate a safe working environment, there's no private cause of action. The employee doesn't get to sue the employer for violating that obligation. And OSHA can bring in action and get an injunction, but to require certain safety precautions to be used in an industry, et cetera. But there's no private cause of action. So it's a difficult question to answer. I don't remember specifically what this particular person was asking, but can someone in the field say to the home office, I don't want to go to that home because I think it's an unsafe environment. I have to walk around and no one's vaccinated and no one's wearing a mask, and I fear for my safety. I think the employee could say that, but I think if the employer fired the employee, I don't know whether that would be a wrongful termination.
Okay. Here is a question. Oh, we're getting all sorts of good questions popping in here now. From Carol, does the state of Florida Department of Labor have resources for business owners on all of this, or is it best to obtain an attorney?
Can you ask it again slower?
Does the state of Florida Department of Labor have resources for business owners on all of this, or is it best to obtain an attorney?
I am the only one who can help you. No, I'm kidding. I don't know. The governmental agencies have so many resources that are available. Google is my best friend, and I suggest that you consider using it as best you can, or make a call and ask. So I can't tell you what resources they have or don't have, but for all intents and purposes, everything I've spoken about today, it is on some website of some government agency or some HR organization or some law firm or some white paper that somebody wrote. So the information's out there and you could get access to it pretty easily. If you have issues or questions, which happen all the time because it's hard to apply what the rule might be against a particular person or circumstance, that's when sometimes you need professional help. So, but the answer generally yes, it's available.
Okay. We have another question from Tulin. This is a great question. Should we have a written vaccine policy by this Monday in order to be compliant?
Yes. So what I've learned in reading what other experts in the field are saying, the prudent course of action is make a decision by the 5th and implement your policy on the 6th. Have it ready. Now, what I didn't talk about, but should have, and I'm glad the question was asked, the OSHA did lift its requirement because of these court decisions. But as soon as these court decisions get reversed, if they get reversed, OSHA is going to put back these requirements, and nobody knows whether they're going to say, I mean, today's the 3rd. I mean, we're running up right against the deadline, but no one's going to know how quickly OSHA is going to give everyone to get into compliance. So if you're not in compliance, the penalty is $14,000 per employee up to, I don't know, 38,000. So some huge numbers are involved that could be very prohibitive. And employers should have policies in place. Now, what you should do is decide what policy you want, develop the policy, have it ready, willing, and able to go. And if and when it becomes clear that the requirement is back in place, then you can act. If you don't do anything, you may find out that the deadline is 2 days later and it takes you a week to figure out what to do.
There's a follow-up question to that, to the question in reference to the policy. Does that apply to companies over a specific employee count?
So, as I understand, the one mandate is for employees with companies with employees of 100 or more, and then there are federal contractor companies, and then there are healthcare organizations. So those are the categories that I'm aware of. And then, different states have enacted different laws and regulations.
Okay. And just to Steve's point, because we get a lot of these questions, written policies about everything are really important, not just COVID. So, which kind of parlays very nicely into the next question. Does Steve's office review employee manuals, or do they have referrals for employment attorneys or advisors?
We look at handbooks and we update them regularly.
And Steve is the only person in the United States that can do that, by the way.
I didn't say that, probably just joking.
I was giving you a plug.
Yeah, thank you. But I have, I work with 3 paralegals, and it's one of the things we do for our clients.
Okay, excellent.
I
And
handle a broad range of litigation, but do a lot of counseling on employment law issues. And then part of what we do is deal with the everyday needs of HR related matters. Hiring, firing, counseling, etc.
all of the good stuff that you need to stay safe and compliant. It doesn't look like we have any more questions coming in. Romeo, has this webinar been submitted for HR credit?
It has not.
Okay.
Yes, it is not. We're going to look into credits for future webinars, but this first one is not.
Okay, excellent. Any other questions out there? Great questions, everybody. Thank you for jumping in there. We still have a few more seconds if you would like to ask some. Also, we really want to thank Steve. He's a plethora of information. Our clients always walk away feeling like they got valuable resources that can assist them in the legalities of their businesses and elsewhere. So we look forward to having him every year, or now maybe every few months, to dazzle you with everything you need to know about the law. Also, I put a little note in the chat. So first and foremost, thank you to all of you for attending. Your business means so much to us, and we love our loyalty and our relationship with our clients. For those of you that don't know this, we take our business very personally. So our clients become family and friends. And so we thank you for putting your trust in us and for choosing PayMaster as your payroll provider. Also, if you do refer any of your friends or family that are maybe with a big box company and not getting the customer service that they need, you do receive a $100 referral credit on your invoice. And then one of the other things I'd like to just reiterate again, if you need more information about the Employee Retention Credit Act, please feel free. I will get to that. I will get to your question. I will not forget to when I saw it come in. Feel free to email myself or Romeo. And if you want to screenshot the chat right now, I've got our contact information right there. And we can go through the questionnaire with you and find out if you're eligible for the ERC. And again, if you've got money sitting out there, like you get those fraud calls that say, hey, you have $200,000 and we know it's not true. It's fraud. This is real. So if you can get real money, go for it. So we would love to help kind of stuff your pockets for the holidays and starting off into 2020. And again, the contact information is right there. And I want to switch over to Q&A because it looks like we have a question that came in. And Tulin, I hope everything's going well for you. I haven't seen you in a long time. Let's see here. Oh, we had a few more questions come in. So one of our employees, oh, we already got to that one. That was a same question. So let's scroll down. Should we, nope. Okay, I'm getting these pop-ups after the fact. So I've already asked them and I'm starting to get these little pop-ups. So I guess we don't have any.
Why don't you ask him again and see if I give the same answer?
You know what? Yeah, that's how we can tell if you're telling the truth or not. Let's see. Let's play, is Steve truthful?
So Rhonda, the most recent one is the run from 202.
Yep.
So it's Tulin, and she's at. Oh, okay. She's asking if should we start the vaccine or weekly testing by Monday, is what she's asked.
Oh, okay.
So my understanding is that OSHA has lifted the application of the ETS, the emergency policy. So it doesn't seem, at least for employers of 100 or more. So it doesn't seem like it may be applicable, but who knows what's going to happen between now and Monday. And then employers allowed to have a policy. I mean, that just made it mandatory. The OSHA rule, is just making it mandatory. So if a company wants to have a policy, they can have a policy.
Perfect. So it doesn't look like, unless I'm getting, we got to thank you very much. So that looks like, I'm going to check chat too. We're kind of bouncing back and forth. It looks like that is the end of the questions. And again, if any questions come up after the fact, I have put in the chat, if you scroll down, I've got mine and Romeo's information available. And we won't try to answer the legal questions. We'll refer to Steve on those. But thank you so much. We do appreciate you. We do wish you and your families nothing but happiness and healthiness and great success for the next year. And hopefully at some point we can all be maskless and, all that good stuff. But Steve, did you have any parting words?
No, not at all. Thank you very much. I enjoy the collegiality and the professionalism. I'll repeat what I've said. I think every time I've spoken that I have the highest respect for Romeo and the staff and the company, and that everyone's in very good hands as far as I'm concerned.
Thank you. And Romeo, do you have any last comments before we leave?
No,
Steve,
just,
I need to know
yeah.
about job security when harassing the CEO, by the way. We'll talk about that later.
No, just again, thank you everyone for allowing us to have an audience to present this.
So be safe, be well, be successful, be happy, and we will talk to you in the next couple of weeks and in the new year.
Yeah.
So take care, everybody.
All right.
Everybody,
Bye-bye.
thank you.
Bye.
Bye.